Hello students, my name is Liz Attia and today's topic is the law and organ transplantation. So the law and organ transplantation. In terms of what we actually mean by organ transplantation, organ donation is the process of removal and transplantation of viable organs from the donor to recipient. In terms of the process, recipients have to be matched with the donor organ in order to reduce the recipient's rejection of the new organ. The relevant legislation as it relates to organ transplantation is the Human Tissue Act of 1983, which is New South Wales legislation. So as it pertains to living adult donors, what the legislation actually says is that a competent adult can give written consent for the removal of regenerative tissue for the purpose of transplantation into the body of another person or for therapeutic, medicinal or scientific purposes. What I'll point out to you at this point is the relevance of the term competent adult, which we've talked about when we've spoken about capacity, and also written consent. So note that this is one of the exceptions where consent must be in writing. And for the purpose of assessing competency and consent to ensure that it is valid, an independent medical practitioner, so not the person who's actually treating either the donor or in fact the recipient, but somebody who's independent to that process, must certify that the adult's consent was given in the practitioner's presence. So the practitioner must be there when the consent was actually obtained or is obtained. That the doctor goes through the process and explains the nature and effect of the removal of the tissue. And the doctor is satisfied that the person was not a child, was of sound mind, and consent was freely given. So here we can actually see enacted in the legislation the elements of valid consent that we've talked about previously. With respect to non-regenerative tissue, there's an additional clause, and that is that there must be a 24-hour time lapse between the consent and the removal of the tissue. And this is almost akin to a cooling off period in contract law, if you like, where, remember we actually said in a few lectures back that consent must be a process of actively engaging with the information and must be reflective. And part of that reflexivity, if you like, part of that contemplation, part of that thinking, part of that engagement in the process is time. So people are given and afforded the time should they actually change their mind with respect to the consent. And a minimum of a 24-hour time lapse is necessary there. With regard to living incompetent donors, the courts can approve the donation of both regenerative and non-regenerative tissue. The only thing I'll actually say to you with respect to that is that the courts tend to be conservative in their approach. So it is not unlikely, but the conservative approach usually adopted by the court is unless the person had an advance directive giving consent prior to the removal of the tissue. Without any directive, the courts are unlikely to actually assume consent and to actually order donation of regenerative or non-regenerative tissue. So usually there must be in evidence some information to the court to actually show that the person, when competent, would have in fact consented to the donation to begin with. Okay, as it actually applies to living child donors, parents may in fact consent to the removal of regenerative tissue to transfer to the child's parent or sibling. In New South Wales, consent must be given by both the parents and the child, and a medical practitioner must give certification in relation to it. So the same sort of process would apply there, that the consent needs to be in the presence of the practitioner, that the practitioner actually certifies that the person is of sound mind, that they explained the information to them around the impact and the effect of the transplantation. If the child is considered incompetent, then the donation can only be made to the child's sibling with the certification of 2 medical practitioners. So again, this is a quality mechanism to make sure that there's integrity in the process, that the child's interests are actually considered. Now, interestingly, with respect to non-regenerative tissue, the Act is actually silent, and we've had no case law since the enacting of the legislation that has actually interpreted that silence and interpreted what the legislation might mean in the spirit of intent with respect to living child donors. So the Act doesn't clearly stipulate what the position is with non-regenerative tissue, but one would presume, based on the living adult donors example, that there would be additional checks to ensure integrity and that the best interests of the child are maintained and protected. With respect to deceased donors, a designated hospital official may authorise the removal of tissue from the body of a deceased person where the body is at the hospital and the purpose is for transplantation to a living person or other therapeutic, medicinal or scientific purpose, where the medical officer has made reasonable inquiries to determine whether the deceased had expressed the wish or consented to the removal of tissue after death and it had not been withdrawn or revoked, the removal may be authorised in writing in accordance with the wish or consent of that person. So there must be some due diligence by the health officials and by the hospital officers to ensure that they've investigated what the expressed wishes may have been of that particular person when they were competent. Where there's no explicit expression of consent and the deceased has not given or objected rather to donation during his or her lifetime, then the next available kin can actually consent on their behalf. Remember though that death is defined as either the irreversible cessation of all brain function or the irreversible cessation of blood circulation, so the heart stops. So the next of kin does in fact under the legislation have the right to revoke or withdraw the removal, the consent as well, which is interesting and which has been the subject of some fairly severe and intense lobbying most recently in recent years, and whether next of kin should have that right under the legislation or not. And I'd also ask you to do some additional research and draw your attention to what might happen when the next of kin actually disagree with each other. So who is given seniority there in terms of relations to the deceased, whether it be the spouse, whether it be the parents, whether it be the child, an adult child of a donor. What is the hierarchy there in terms of the legislation? I will leave that with you to do some additional research and flesh that out in the tutorials. So what does the law actually say in terms of the commodification of human tissue? What are the property rights in human tissue? The legislation is fairly clear in that it prohibits the trade in human tissue, so the buying and selling of human organs and human tissue. A living person cannot sell his or her human tissue. With respect to deceased persons, the general common law position is that there's no property in a corpse. And this particular issue was considered in the case of Doodwood and Spence in 1908, where because of the nature of the corpse in this particular example, it was the preserved fetus of a two-headed corpse. And because of that, how unusual that was, the court found that in terms of value, if it had actually lived, it would have acquired a value and became property. But this case is an exception to the rule. And It's generally found that there's no property rights in human tissue. And the reason why there's no commodification and a person cannot sell their human tissue is to prevent the position where vulnerable people might be taken advantage of. And the law is quite clear in safeguarding the interests there of individuals who might be preyed on in terms of the market for buying and selling of organs. So that's certainly the position in Australia. Thank you, students. That brings today's topic to an end.